My name is Henk Low. I'm the current chairperson of the Chartered Institute of Arbitrators in South Africa. The Chartered Institute itself being an international body, over 54 countries, representing some 17,000 arbitrators worldwide. I think it is probably the biggest body out there. The Chartered Institute is both a training institution, academic institution, and it provides the appointment of arbitrators, which it appoints from its lists, and specifically the President's list of arbitrators. Within South Africa, we do the same thing, but on a much smaller scale. We have our own website, we have our own members, and we do appointments from members. Our criteria currently for the appointment of members is that a person should be a member of our institution. And all our members are registered in the UK. They obtain their membership there, and then they obtain their membership status or associate status or arbitral status. And once they are there, they do academic qualifications, they qualify themselves as fellows, and then they distinguish themselves by going onto the Chartered Arbitrator list. Now, from our perspective, we allow parties in South Africa to, by way of party autonomy, inform us who they'd like to appoint from our list of arbitrators. Our list of arbitrators is on our website, and there are also members not on it. But once we have a selection criteria in terms of the number of years of the person at the bar or at the sidebar, the qualification of the person, be it an engineer, be it an accountant, be it whatever the nature of the dispute is, we will then ensure that we find the correct party or the correct person to act as an arbitrator in the environment. Now, important to us is to have parties or arbitrators appointed that have experience in the matter and that can deal with the issues to be dealt with and to be arbitrated and to be resolved effectively and cost efficiently. Now, as you've heard tonight, one of the big issues is the issue of costs. The perception currently has been that arbitrators and arbitration is an expensive process, in that in addition to what you would do in the legal process, civil litigation process, you now have to pay an arbitrator his fee. What you've seen tonight is, because of the time duration of litigation, matters being set down now in 2032, there's a certain time, value, cost and inflationary issue considering that process. By way of dispute resolution and arbitration, we can tell you that you'll have your matter finalized within a period of, at a maximum, 2 years. We've seen tonight that a 3 billion rand matter has been finalized in 2 years, with a massive cost saving associated with time, value, money. And of course, there's also certain emotional issues attached to it. And also, parties that are now witnesses in the process are taken out of the core function, and they cannot ensure optimum shareholder value, which is what they should do for the business in which they operate. So effectively, the takeaway from tonight is there is a parallel process, which is now called dispute resolution, which can run and ensure that parties have effective and speedy justice. That does not necessarily mean that they've completely contracted themselves out of the judicial system. In the event that they want to review an issue, they can, in terms of the current Domestic Arbitration Act, still approach a court and have it dealt with by the court, with courts having a jurisdictional element in the matter. So we provide an effective, speedy, cost-efficient process. Thank you.
Okay, I'm Jack Ferris. I'm a director at Klip Dekker Hofmeyr, or CDH. So today, the 6th of May, we hosted a joint event with the Chartered Institute of Arbitrators, the South African branch, where we discussed the importance of the developing dispute settlement marketplace in South Africa. And the broad discussion was about, we have a court system and a process where parties can ultimately initiate dispute settlement in the courts, but there's also evolving process where the court system are so over capacitated or constrained because of the constraints on the state in terms of funding and a number of other factors that impact the judicial system. There's other methods that's being proposed and essentially are now effective, such as mediation, which is parties trying to resolve disputes amicably before it gets to a court process, or the alternative to litigation or court process being arbitration, where parties can consent to resolve their dispute in a private forum by a private appointed arbitrator. Obviously, part of the discussion of having regard to the context of South Africa and its society is obviously also making sure that those processes are also transformed. So making sure that the mediators that are appointed are also reflective of the society we are in, whether it's the mediators or the arbitrators. So what the roles that institutions can do to make sure that that's done, and ultimately to ensure that disputes are resolved. So, and that's the fundamental part, is that whoever the parties are, they want to make sure that if it's a commercial dispute of 100 million or 1 billion rand or a sensitive issue, they want that dispute to be effectively resolved and not to wait until 2032, which is the current court role in Johannesburg, to have a trial matter resolved, to resolve it as quick as possible and as efficient as possible, and to maintain potentially the relationship if it's a mediation. So that's basically what we spoke about today with the the Deputy Judge President of the South Gauteng High Court. And also we spoke about cost-benefit analysis and how, if you look at the cost of arbitration and cost of litigation, that it's potentially actually cheaper to arbitrate a dispute than to go into the court process, which is a very long, dragged-out process based on the current hurdles that the court is facing.